Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. This is the 18th episode of the Latham & Watkins Drug Pricing Series, and I'm Chris Schott, a partner in the healthcare and life sciences practice in our Washington D.C. office. I focus my practice on all things market access, and that includes manufacturer compliance related to the Medicaid Regulatory Program, Medicare Parts B and D, and the 340B drug pricing program, as well as, of course, implementation of the Inflation Reduction Act and other healthcare reform initiatives such as state laws. Joining me is Danny Machado, an associate in our Washington, D.C. office.
Hey, Chris, how's it going? And if I could take this opportunity to remind our listeners of the relaunch of the Latham & Watkins Drug Pricing Digest, where we essentially track reports or coverage from the trade press, government publications, releases, and court opinions. And our intention is to distribute this digest at the start of every other week. So if you would like to get this in your inbox, we're going to include a subscription link in the podcast notes.
Thanks, Danny. Today, we're happy to welcome two guests on the podcast, Latham partners Nate Beaton and Bill McConagha. This is Bill's third appearance on the podcast, so you might be familiar with him. But Nate, why don't we start with you? Do you want to introduce yourself?
Sure, Chris. Thanks for having me. I'm a member of the healthcare and life sciences practice here in the Washington, D.C. office as well. I focus my practice on FDA regulatory matters across the FDA-regulated product lifecycle and across all FDA-regulated product categories from pharmaceutical products, medical devices, biologics, as well as other FDA-regulated product categories.
Thanks, Nate. Bill, do you also want to introduce yourself?
Yes, Chris, thank you very much for having me back. I'm thrilled to be here. I am also a partner in Latham's healthcare and life sciences practice based here in Washington, D.C. I cover all things FDA, from pre-market regulatory issues to post-market issues and enforcement. I worked at FDA for about 17 years in a variety of capacities before I joined private practice.
Thanks, and thank you for joining the podcast today. In each episode, we focus on a specific topic that is relevant to market access, drug pricing, or the pharma and healthcare sectors more broadly. And after discussing the substance, we ask the question, which Olympic sport is it like? And we have the list of Olympic sports here to see which most resembles the topic in terms of strategy, complexity, or frankly, level of conflict. So, Danny, what is our topic for today?
Today, we'll be chatting about the Medical Device Manufacturers Association, or MDMA, annual meeting, which just concluded here in Washington, D.C. And as we've done in the past after significant conferences in our prior podcast episodes, today we want to do a bit of a readout and discuss key takeaways from this conference, which both Nate and Bill attended. So maybe, Nate, if we could start with you, could you tell us a little bit about the MDMA annual meeting and its significance? Just broadly, who are the attendees at the MDMA conference?
Sure. Thanks, Danny. To start, MDMA itself is a Washington, D.C. based trade association for the medical device industry. And it, as an institution, has a significant role, both in terms of the stakeholders that attend the annual meeting and are that are members of the organization, but also in its own right as a key player in terms of engagement with Congress and the executive branch representing industry across issues that are important to device manufacturers, and in particular with respect to user fee reauthorization negotiations with FDA. The annual meeting brought together manufacturers, as I said, but also investors, policymakers, and related professionals and other stakeholders. And the meeting has a conference component, as you mentioned, but it also includes what they call a congressional fly-in, where industry members have the opportunity to visit the Hill to meet with congressional staff and congressional members to discuss the companies and the challenges that they face. One of the things that stood out to me from the meeting was the participation of key government officials. With the change in presidential administration, there have been several comings and goings within the executive branch, and other conferences and events of this nature that we've attended recently that would typically have had federal agency officials participate have really struggled to bring in and get those officials to either speak or attend. We had a number of folks from the executive branch participate, two that stood out: Dr. Michelle Tarver, the director of the Center for Devices and Radiological Health, or CDRH, as well as John Brooks, the deputy administrator and chief policy and regulatory officer at the Center for Medicare and Medicaid Services, or CMS. We also had a chance to hear from members of both parties on the Hill.
Thanks, Nate. It sounds like you had a nice broad-based attendance there, and it's great to hear that there are actually government officials attending some of these meetings. I know that some other conferences trying to get organized are having maybe issues getting responses from government attendees. So what were some of the key issues that you were watching for at this year's meeting? And maybe, Bill, we can start with you on this one.
Sure. Primarily, I was there to listen. We'll talk in a moment about the fact that I was on a panel, but I was very interested in hearing from the attendees and the government officials, what they were concerned about, what they're focused on, where are the uncertainties, where are the challenges. Among the things I was interested in learning a little bit about and talking with people about are kind of how are these medical device companies sorting through the changes at FDA as it relates to product review and approval, and essentially, moving the freight, if you will, in traditional ways. How is that changing, if at all? Questions about evaluating the legal landscape, such as the recent decision on LDTs. What does that portend, if anything, for new technologies that would be regulated by FDA and the Center for Devices? Very interested in hearing about issues relating to compliance and enforcement, getting a sense from others what they think might be areas of focus. I certainly had thoughts of my own, which we can elaborate on in a moment, but was really interested to hear from the companies what they were anxious about. And then also particularly interested in hearing about questions around global supply chain, especially with the tariffs, how that would impact development of products, accessing components that were made abroad, even for domestic manufacturers, and trying to figure out what kind of strategies the industry is employing as it confronts a reality that is impacting many industries.
Thanks, Bill. That's fantastic as far as issues that you were looking out for. And as Nate explained, this event brought together folks from across the industry, folks from Congress, FDA, CMS, the media, related professionals. And now, I guess it would be great if we could move to what were some of the highlights of the discussion that you heard this year. Did anything stand out to you as key themes across these various domains? And Nate, I wonder if we can start with you.
Sure. I mean, maybe to put a finer point on what Bill said, I mean, one thing that was interesting to me as an FDA regulatory attorney, having attended the annual conference for a number of years, was this was actually the first meeting that I attended in which Jeff Shuren, the longtime CDRH director, did not participate. So I was really eager to hear about the priorities of his replacement, Dr. Michelle Tarver, as center director. Her session was styled as a listening session, and it was designed to provide MDMA with an opportunity on behalf of its members to sort of put forward some of its priorities or concerns. But I was really focused on her responses and what we could glean from her priorities coming out of that. Two that stood out to me was sort of what she described as right-sizing the Q submission program. That's the program for interaction between medical device manufacturers seeking authorization of their products and the agency. So that can be anything from a pre-submission meeting early on in development or what's called a submission issue request, where you can hash out with the agency, more discrete disputes with respect to, how the agency interprets data in the context of a pre-market submission, for example. And really her focus was on ensuring that the program is efficient with respect to agency and stakeholder resources, but still providing actionable feedback. So she gave some examples of, folks coming to the agency with questions in a pre-submission that were so broad or were so early in the program so as to not position the agency to provide meaningful feedback. Another one that she touched upon was fostering the development for products for use in the home setting. She focused on facilitating, the development of those products for use at home, and really, in particular, to be integrated to and designed with the home in mind. And she touted CDRH's Home as a Healthcare Hub initiative, which is designed to develop new paradigms for developing and testing those products for home use. The other thing that came up over and over again that I think really speaks to the cross-cutting nature of this conference and the types of players who participate was what several stakeholders called the gap between sort of the concept and development stage for an FDA regulated device, and then through authorization and market access and adoption. So, for example, a medical device manufacturer may need to develop certain test data or conduct certain studies in order to obtain authorization for the product, only to then find that in order for that product to be adopted in the market or to obtain coverage and reimbursement from public or private payers, that additional evidence or support would be needed. And so this is important to both innovators in the medical device space, but also the investor community, because having an opportunity to compress that coverage to payer adoption lifecycle has the potential to shift the risk profile and value proposition for these types of medical technologies, and therefore to spur greater investment. And this was something that came up in Dr. Carver's remarks in terms of her desire to incorporate more information about what payers and patients and providers need when thinking through the types of information that FDA seeks. And it was also something that came up in John Brooks' remarks, particularly focused around the Biden administration's TSET pathway proposal. That was a final procedural notice that was issued by the Biden administration in August 2024 to establish this TSET pathway, or transitional coverage for emerging technologies pathway. This would provide a pre-market evaluation by CMS of certain FDA-designated breakthrough devices prior to FDA authorization to potentially allow transitional Medicare coverage for the device. In other words, allowing these products to obtain coverage to get reimbursed earlier than they otherwise would following FDA authorization. But one of the things that we heard from a number of stakeholders is that they felt that the TSET pathway perhaps doesn't go far enough. The Biden administration itself indicated that it would seek applications from manufacturers to participate in this pathway, and they only anticipated accepting 5 applications per year. This is in contrast to a proposal to address the same problem by the Trump administration. The Trump administration actually issued its own final rule, the Medicare Coverage for Innovative Technologies rule, which would have provided for much broader coverage for devices designated as breakthrough by FDA. However, that rule was rescinded by the Biden administration before it became effective. And so one of the things that we heard a lot about in the conference was efforts in Congress to pass legislation perhaps more akin to the Trump administration approach. And we heard from John Brooks at CMS that the administration is now considering sort of a potential middle ground between those two proposals, not to provide this transitional coverage for all FDA-designated breakthrough devices, but perhaps to go further than the 5 applications per year under the Biden proposal.
Well, Nate, that sounds like there was a really deep discussion here, especially following the change of administration. And I can say on the drug pricing side, the first of the 2 big annual drug pricing conferences is taking place in Philadelphia. So we'll see if there's an equally in-depth discussion there. So stay tuned for a future podcast episode that will have a readout from that conference. So it sounds like from looking at the agenda that one of the topics here was also compliance. And Bill, like you mentioned, you spoke on a panel on compliance hot topics. Can you share with us some of the points you made on the panel and also what you heard as takeaways from the panel discussion?
Yeah, thanks, Chris. Happy to discuss. So, as you say, I was on a compliance panel. I was joined by 2 great lawyers from another law firm who made wonderful contributions, and also a moderator from MDMA who is very steeped in compliance issues and was kind of wonderful in directing the discussion. It was a nice, I really felt like robust discussion as opposed to folks who just, all offering unilateral soliloquies. I think at a high level where we all netted out in terms of kind of common theme was this sense that as it relates to compliance, our thinking, certainly my thinking, is that the False Claims Act and the anti-kickback statute will remain a focus for enforcement. My sense, our sense, the panel's sense is that fraud is a bipartisan issue and nothing about that has really changed. And the FCA, the False Claims Act, is also a moneymaker for the government. And let's not lose sight of that. In 2024, there were nearly $3 billion in FCA recoveries. And of that, nearly $1.7 million was for FCA cases relating to healthcare. And so there's every incentive for these matters to continue in appropriate circumstances. Much has been said about changes at the Department of Justice, and I think it's important to weigh all of that. I don't personally think that DOJ is going to become less active in the FCA space. But even if they do, I think it's worth remembering that relators can bring key TAMs on their own and proceed on these FCA cases on their own, even without DOJ support. And so insofar as you have an active plaintiff's bar, you have, active, relators out there, there will continue to be these incentives to bring these cases. In my view, especially as it relates to the medical devices, the articles we were discussing at the MDMA conference, the focus of these will be on payments made to healthcare practitioners. So these would be very much the sort of issues that have historically been focused on. I think it'll continue. Payments to HCPs for speaker programs, for grants, key opinion leaders, payments made to consultants, I think this would be the primary focus for medical devices. I will add that in the case of pharmaceuticals, I think there will also be continued focus on patient assistance programs and other payments intended to offset out-of-pocket costs for patients or to impact use and reimbursement. And on that last point, as it relates to reimbursement, I will note that the MDMA audience seemed particularly interested in compliance issues as it related to reimbursement. And so my thought is that this may be a topic worth exploring in depth in a future podcast, Mr. Schott, because I think there is a real appetite for kind of the reimbursement issues, how they're being impacted, and what it might mean in terms of FCA and AKS enforcement.
Sounds good, Bill. We're happy to have you back a fourth time.
Right.
Not a problem.
I have so much to say, or you can't get rid of me. Maybe it's a combination of both. One question we got from the audience is whether there are kind of any particular areas of focus as it relates to FDA regulatory issues. And, on the compliance front, I'll note that well before this administration in the 2023 HHS-OIG guidance, the big update, there actually was interesting language in there that talked about the idea that compliance in these FDA-regulated companies should exercise more oversight over the quality functions. And so one interesting thing is to see how have companies in the last, 18 months to 20 months tried to deal with that. And I think what we're hearing and what was a theme at the conference is this idea that it's important for there to be a relationship and some level of connection and coordination between compliance and QA, such that any kind of major existential issues that arise in the quality setting that could actually impact compliance get elevated. But by and large, they continue to operate as independent entities within these companies. There's just a better sense that compliance has some insight into what's going on as it relates to the kind of most serious issues coming out of the quality systems. One other thing I'll just add that I thought was really interesting discussion towards the end of the panel was we spoke about a recent focus on FCA cases related to wound healing. And the panel collectively explored why that has been the case. What about kind of wound healing type of issues would lend itself to more activity as it relates to fraud or reimbursement? And the consensus was that sometimes when companies are operating in gray spaces as it relates to FDA oversight, they're less vigilant about their compliance programs. And so the takeaway was to be thoughtful about reimbursement and grants and payments, no matter the regulatory status of the product. And so applying this kind of, to real examples, I think what this means is if you sell HCTPs or market unapproved drugs, maybe even LDTs, that you still need to be careful when you think about the way you structure your compliance program and your arrangements with HCPs. If there are federal monies being offered for reimbursement.
Bill, one thing that struck me in those comments is, and as you alluded to earlier, we heard quite a bit in the hallways and various chatter about the impacts of potential tariffs and supply chain issues. And it just strikes me, your comments with respect to QA, if folks are looking, if manufacturers are looking to source alternate suppliers to move production, that presents another opportunity for greater activity that could result in foot faults.
Yeah, I think it's a great point. And, one of the things I'd like to talk about in a moment is there going to be, based on these recent executive orders, kind of a new enhanced focus on, QSR compliance or GMP compliance in these manufacturers abroad, not to mention domestically. And how does that also impact the global supply chain? So, yeah, the point is very well taken. Totally agree.
Thank you both for that fantastic background on the enforcement trends that you heard about during the conference. And I suppose looking ahead, putting your, prediction hats on, what would you say we could expect in terms of regulatory enforcement in this year, in 2025?
Thank you, Danny. I've never heard my remarks characterized as fantastic. So thank you for that. The question you ask is a good one. And I think the honest answer is that it's really hard to predict how FDA is going to behave over the next year or two. Hard to predict exactly how CDRH will respond just 100 days into this administration, but certainly do have a few thoughts on this. So first, just to level set, I think it's important for us to all recognize that this is a time of serious transition at FDA. Not only is there a new administration that has voiced serious concerns about how FDA does business, but there is also new leadership in the centers. And Nate alluded to this earlier, right? After years of having Dr. Jeff Shuren and Dr. Bill McConagha running the center for nearly a decade, there's new leadership with Dr. Tarver and her lieutenants. They actually, took over before the new administration came to power. But we have this kind of enormous sense of transition. And what comes with that is a loss of some institutional memory, also opportunities for fresh thinking, new leaders to think about how they are going to approach the enormous number of challenges that FDA has in terms of its administrative workload and its enforcement priorities and the like. On top of that, we know that Janet Woodcock, who essentially was drugs at FDA, retired in the last 2 years. Peter Marks, the Dr. Peter Marks, the head of CBER, has resigned, and he's recently been replaced. So there is really a sense that we are at a kind of a milestone or inflection point with FDA, and I think it's hard to tell just 3 months into the administration exactly what's going to happen. The new leaders still need to get a sense of how they're going to handle day-to-day enforcement, especially over things like technical violations that may not pose an acute safety threat. For years, I think we had seen CDRH becoming less enforcement-minded. They were prepared to take action in the case of real fraud, but we didn't see a lot of warning letters coming out of CDRH. I have no reason to believe that will change, but where the priorities will shift to is a somewhat open question. I expect, FDA to remain actively focused on this administration's priorities. And so we'll see that very much in the Center for Foods. I think we'll continue to see FDA taking action against what it regards as unsafe food products. And I think this will lead to fairly massive changes in the way that the safety of food is evaluated for all of you who are familiar with agency announcements as it relates to, certified color additives and also self-certified GRAS. For medical products, and I very much welcome your thoughts on this, Nate, in a moment, I expect FDA to remain very focused on fraud cases, especially with respect to medical products. I think that there will be a sense that these are the cases where there's a really knowing effort to commit fraud against the agency or against consumers. And consistent with that, I would note that, hot off the presses is the executive order from President Trump on over-criminalization and regulations. And it essentially discourages across the government, but this would certainly apply to FDA and DOJ to the extent that it enforces the Food, Drug, and Cosmetic Act. It discourages criminal enforcement of strict liability offenses where there is no proof of bad intent. And so that is kind of really interesting in that, the Park doctrine in the FDA space is very much based on this idea that with the responsible corporate officer doctrine, criminal cases are brought even in the absence of a specific intent as strict liability misdemeanors, to make a point as it relates to enforcement. And they are not much brought anymore, even though there were efforts in recent DOJs to prioritize them. We still see FDA bringing these cases in instances where there is widespread injury, even in the absence of intent. So examples would be like, the NECC compounding case, issues that relate to, adulterated foods that get recalled. There has been, I think, in FDA's judgment, even in recent years, a time and place for the use of this tool in enforcement. It'll be very interesting to see if any part of FDA, much less CDRH, continues to bring Park doctrine cases in light of the executive order. One other executive order that I think is worth noting, and kind of the final thought I have as it relates to enforcement, is that I think actually where we may see the most active form of enforcement will be in relation to establishment inspections, which most people don't think of as enforcement in the traditional sense because, people aren't showing up with handcuffs and, the nylon jackets that say please. But, FDA inspects medical product establishments across the world that sell products in the United States. And on May 6th, there was an executive order, I guess it was May 5th was an executive order from the Trump administration, followed by a May 6th announcement from FDA about the agency's intent to expand the use of unannounced inspections at foreign manufacturing facilities that produce foods, essential medicines, and other medical products. that are going to be marketed to American consumers and patients. And Commissioner McCary said that essentially foreign companies have long enjoyed a double standard because in the U.S., advance notice is not given. Surprise inspections occur. But for those foreign companies that operate under FDA jurisdiction, there has historically been advance notice given before facility inspections. And I think the reality is that this longstanding practice of announcing foreign inspections is grounded in a number of practical realities, such as visa requirements and travel arrangements and the availability of interpreters. And frankly, the fact that many of the countries in which these facilities operate are sovereign nations. But that said, I have heard about some unannounced inspections already taking place in India. And so it's clear that this is an important focus for this FDA. I will add that the commissioners also reportedly said that FDA will reduce the length of future inspections abroad, thereby enabling FDA to complete more foreign inspections with fewer resources. There has been, I think, a lot of skepticism about whether FDA can achieve these dual goals. Many believe the only way to do more foreign inspections with the same resources is to truncate the visits, and that would, in theory, lead to less thorough reviews. And I'll note that Michael Rogers, who was a longtime FDA official and was the head of the field inspectorate at FDA, resigned the same week these announcements came out. But I think the bigger story in this is not whether or not there will be challenges as it relates to resources or unannounced inspections, but the fact that the administration and thus this FDA are clearly focused on foreign suppliers, and they're focused on them as part of this broader, what I will call, enforcement effort, as promulgated in this executive order. And I expect the number of foreign inspections will increase, especially in companies like India and China that supply medical manufacturers in the United States or are themselves establishments where finished products, be they devices or pharmaceuticals or biologics, are manufactured and sent to the U.S. And I expect that we'll see more 43s and more regulatory findings related to these foreign inspections. And so I intend to watch very carefully whether FDA actually classifies a higher percentage of these foreign inspections as official action indicated, as OAI, that it has in the past. And the OAI, for our listeners who aren't familiar with it, is the highest designation that FDA is concerned about what it's discovered and that it's prepared to take additional action, be it a warning letter or an import alert. And the import alert is an incredibly powerful tool that allows FDA to block foreign companies' access to the U.S. market on the grounds that its products, and I quote, appear to violate certain requirements of the Federal Food, Drug, and Cosmetic Act, such as GMP or QSR in the case of devices. And so, in the case of domestic manufacturers, civil injunctions have to be brought as adversarial proceedings filed in federal district court. With all those related due process requirements, if you want to shut down somebody who is selling a product manufactured in the U.S., be it a medical device or pharmaceutical. In the case of foreign suppliers, FDA can put a company on an import alert as an administrative action. And while such administrative actions are subject to judicial review, it begins with a unilateral administrative act by FDA that is tantamount to a de facto injunction. And so I am really interested to see if FDA uses this as a tool in its effort to kind of police the quality of foreign products, or I should say products made in foreign countries that are intended for the U.S., but also to see if it uses this as a tool in its effort to help move manufacturing back within the U.S. And so it's a point that I've made, I think, less directly in a prior podcast, but I still think it is a really incredible tool that FDA has, and I've got my eyes open about it.
Yeah, I think that, in addition to FDA, and Bill touched on it a little bit, this is not only a time of transition with respect to FDA leadership, but across the executive branch. And so, even if there are some indications that in certain areas FDA may be less focused on enforcement, we also will need to monitor the priorities of, other officials within the new administration that have the ability to bring action under the FDCA, whether that's Main Justice at DOJ, U.S. attorneys' offices, others outside of FDA, but sort of can bring ancillary claims. Bill talked about FCA. So, what are the priorities of HHS OIG, the Office of Inspector General within HHS, and then also CPB, Customs and Border Protection, just to name a few.
And one quick thought on justice. The news is changing constantly, so I don't know where we are exactly today. But at last reading, my understanding is the Consumer Protection Branch in justice has largely been dissolved, and the attorneys therein have been spread to other divisions within the Department of Justice. And that's significant because CBP is the division within justice that historically had handled FDA's biggest criminal and civil cases. They were the group within justice who worked, repeatedly and consistently with FDA and had a level of expertise and facility with the Federal Food, Drug, and Cosmetic Act. There are certainly criminal cases that have been brought by, U.S. attorneys' offices across the country. It's not to suggest that CBP alone has acted in furtherance of FDA's enforcement mission. But it is interesting that, to Nate's point, that as we kind of evaluate how is DOJ going to handle its enforcement priorities in this space, the division that has been tasked with it for the entire time I've been in the Food and Drug Bar no longer exists.
Well, that's certainly a lot to think about, and you gave us a lot of interesting trends here on enforcement, how it plays into the international scope. Maybe to wrap up our conversation at a high level, I can ask both of you to sort of make a brief closing statement on other topics that you might have your eye on coming out of this conference. So Nate, maybe we'll start with you on that.
I think like many in the room at the conference, I'm looking to see how CDRH handles its user fee performance in the coming weeks and months. We've touched quite a bit on changes with respect to leadership. There have been reductions in force within HHS, and there's been discussion around reorganization, although at the time of the recording, that hasn't largely affected FDA to date. But each of those things are things that could impact the timing for FDA's review of medical device product applications, for engaging meaningfully with manufacturers through the Q-Sub program and otherwise. And those are the types of things that I'll be looking ahead to coming out of the conference.
No, those are great points. I too am very interested to see how CDRH handles the day-to-day. I'm very interested to see how companies feel empowered or not in the area of product promotion domestically. The agency, as the listeners may be aware, fairly recently issued a new guidance, the SIUU guidance, the Scientific Information on Unapproved Uses guidance, that is, I think, more permissive than ever in terms of the sorts of consistent with label or kind of off-label information that can be disseminated. But at the same time, I think much more quietly, the agency also issued an addendum to its memorandum on First Amendment principles, which I think had last been updated in 2017. And they quoted heavily from the Factel case, which is a case coming out of the First Circuit that could be read. And I say could be because I think there's still work to be done here, but could be read to narrow Coronia and Ameren, which are kind of landmark cases in the Second Circuit. And it suggests there may be something of a circuit split. And my point in raising this is not to say that I think FDA is going to be any more active than it has been in recent years in this space, but it is to also see how the industry reacts. And my own instinct is that it's important to be careful and thoughtful. And I would suggest that companies follow the guidance and the safe harbors therein. For those that don't, I will be very interested to see, especially in the medical product space, what, if anything, FDA does about it.
Well, thanks for that in-depth background and the takeaways from the conference. And certainly it makes sense for the companies in the space to monitor these trends that you've identified on approval, promotion, and enforcement that we've talked about here in some depth today. So before we go to the question we had posed at the very beginning, namely which Olympic sport is alike, let me echo what Danny said at the outset and also mention the relaunch of the biweekly Drug Pricing Digest, and we'll put the subscription link in the podcast notes. So Nate, we'll start with you. What do you think? Which Olympic sport is alike?
My takeaway from the conference and the Olympic sport that came to mind for me would be a relay race. We saw across both the participants and also their concerns a real focus on sort of that handoff between concept, development of a product to FDA authorization, and then on to commercialization, coverage and reimbursement, and an acceptance by the provider and payer community. So I think that, in that sport, having a seamless handoff is really, one of the keys to being successful in a race. And that's something that, several stakeholders highlighted as an area of opportunity, and something that members of government, again, also mentioned as something, that's a focus for them.
Yeah, makes sense to me. You definitely want a good team and have a good strategy for that. Bill, what do you think? Any thoughts about Olympic sports?
Yeah, that's really painful. That's a good answer, and that's going to be hard to follow. And this is my third podcast, and I think now the third time that I will have the inferior Olympic sport. But I'm going to double down on mine, which is kayaking. And I say that because I think with all that's going on, there is a need to be balanced. There's a need to be nimble. You have to concentrate, be fully engaged. There will be periods of rough waters. There will be periods of calm. I feel the regulated industry is going to have to kind of recognize both and adjust to both quickly. And look, if you hit a bump in the water, I don't know what the term is, but you get rolled, you roll back up, and you keep pressing forward, and it's exhilarating. And I will say that as it relates to the team concept, what I understand about kayaking is that it is a team sport with combined times. And so there's this kind of sense that it is a team effort that is based on these kind of strong individual efforts, dealing with kind of different challenges as you go on the course. And so that is my Olympic sport.
So I'm hearing ride the wave.
Ride the wave. Well said. Yes. You've managed to distill into one phrase what it took me 5 minutes to describe. Well said.
And there's a great link to Washington because we have Great Falls up here. You can kayak down Great Falls, and that's certainly very exciting. Danny, over to you. Which Olympic sport do you think it's like?
I think baseball. Both Bill and Nate mentioned the Trump administration's heightened attention to prevention of healthcare fraud and abuse. In baseball, the umpire kind of serves as a vigilant enforcer of the rules, right? Making those critical calls in the moment about to maintain the integrity of the game, identifying balls, calling strikes. So whether indeed the FDA will be more active or not compared to prior years, it'll still be very important to be thoughtful. Chris, what do you think? What Olympic sport did you pick?
Yeah, I'm going to have to go with mountain bike cycling. And I'm thinking a little bit like Bill here. So this is described as involving cycling off-road on mountainous or very hilly terrain using a specialized bicycle. So what would make more sense, speaking about devices, than to have this very specialized bicycle as the device to succeed here, going into the mountainous and hilly terrain that the new administration seems to be increasingly sending us into. So I have to go with that. And I think that nicely wraps up our podcast today. I think we're all ready for a bit of a break here. Danny, what do you think? Where are we going for the after party?
Well, I mentioned baseball, and I know that we were talking earlier about baseball games. It is mid-afternoon, and I wonder if we should just hop on over to the Nats arena and park to go watch a little baseball game. What do you guys think?
Bill, Nate, you on board with that?
Sounds great.
Yeah.
All right, I'm certainly ready to go. Thanks to Nate Beaton and Bill McConagha for joining the podcast today and sharing insights regarding the MDMA annual meeting, and thanks to Danny for being a moderator. And thank you to our listeners for checking out the Latham & Watkins Drug Pricing Series, which is part of our Connected With Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins, LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins, LLP, and you should not send confidential information to Latham & Watkins, LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. and you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.